Hey guys, it's Anthony Bandiero here with Blue to Gold Law Enforcement Training. I'm about to head back to the airport. I'm in New Orleans, and I wanted to share a question that a student asked me in class. And I think it happens quite frequently, so hopefully you get some value out of this. The question is whether or not officers conducting a knock and talk may put their foot in the front door in order to chalk it open while talking to the occupant without implicating the Fourth Amendment. And the short answer is no. That does implicate the Fourth Amendment, and if it does, the officer needs what's called CREW. It's an acronym that I came up with that stands for consent, or a recognized exception, or a warrant. You need one of those three things in order to do something that implicates the Fourth Amendment. Now with that answer, let's roll into the why. The reason is that chalking open the front door, just kind of putting your foot there to prevent them from closing, is either done for one or two purposes. One, the officer may be trying to search, and look around inside the house to see plain view evidence. Well, the plain view evidence rule is when an officer is lawfully present and then sees, hears, smells something that gives him probable cause that it's contraband, usually. But the better way of saying plain view is right to be, right to see. With that, does the officer have a right to chalk open the door with his foot to have a better look into the home? And of course the answer is no, right? Because that is a home, and it is clearly protected under the Fourth Amendment. It is the most protected area under the Fourth Amendment. And before you can do it, you have to have more reason than simply, I really just don't want this person to close the door on me because I want to talk to him or her. So if the officer's motive is to search, and it chalks open a door, it's not plain view, it is a search under the Fourth Amendment. The other reasons that some officers do this is to prevent the occupant from closing the door before the conversation is over. But again, just like I said, preventing a person from closing their front door is an activity implicating the Fourth Amendment. So this would be a seizure if that was the motive here, because a seizure occurs when an officer intentionally interferes with the possessory interest of a person, of their property. The occupant is lawfully present in that home. Therefore, they have a right to close the door and not talk to police. That is a constitutional right. They do not have a constitutional mandate to cooperate with police. Therefore, if they chose to close the door, that is their choice. And if the officer prevents that, they are interfering with their possessory interest, that is the home, which implicates the Fourth Amendment requiring CREW. Do you have consent? Well, surely not, because the person wants to close the door and you're not letting him. Do you have a recognized exception? Well, you may, but you better come up with something, because do you have exigency? Do you have an arrest warrant? Do you have community caretaking? That seems a little weak, because if they're out and about and they're talking at the door. But if you're investigating a domestic violence and the husband is trying to close the door on you and you're trying to make sure that the wife is okay, that would be a recognized exception. And the final one is, do you have a warrant? Which you wouldn't have, or we wouldn't be talking about this. So I hope this helps. It's a great question. Keep them coming. And you can reach me at bluetogold.com. Thank you and stay safe.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.